Thank you. With that, Mr. Edwards, you may proceed. Is the podium in the right place?
Yes, Your Honor. The state will exercise an opening and concluding argument, and I will proceed on behalf of the state first. If you please the court.
Yes, sir. You're going to use the podium, you're going to use the mic, or you just got a big mouth? Which one you going to do?
All of you.
Okay. He does have a big mouth, but okay. Yeah, let's go.
Ladies and gentlemen, Ryan Cooper is absolutely 100% guilty of all of the charges that have been brought before you. There should be no doubt in your mind that Ryan Cooper is guilty. And look at it. You need to look at him. You need to consider the enormity of what he did in this situation. He took away the life of the mother of his child, and more than that, he took away the very existence of the mother of his child. The very existence he tried to just get rid of, that she no longer exists. That's the enormity of what he did. And look at him, and I want you to look at him, and I want you to hold him responsible for the things that he has done. You have overwhelming evidence of his guilt. Ladies and gentlemen, Ryan Cooper is guilty, and what I want to talk about first is, number one, the charges that he has. He has several charges, including murder, malice murder, felony murder, aggravated assault, aggravated battery, possession of a firearm in the commission of a crime, and concealing the death of another, hindering the discovery of the body of Lacambria Toomer. Those are the things that he did. Those are the things that he is guilty of. And we're going to go over all of these things and the law that is the basis for you to return the verdict of guilt as to each and every count. Ladies and gentlemen, you have a trial, which is a search for the truth. And we search for the truth, and you have certain tools for the search for the truth. Number one, an indictment is not evidence. We're going to talk about what evidence is in a moment, but an indictment is not evidence. It is the means by which a person is brought to court. It is the document that shows the individual what he is charged with. And that is what you will have, but it is not evidence. So the evidence is what comes from this court. Also, what is not evidence are the arguments, questions, objections of lawyers. That is not evidence. Questions, objections, arguments of lawyers is not evidence. It's not. It's not. Ladies and gentlemen, what is evidence? And ladies and gentlemen, evidence comes in generally 4 different forms. 4 different types of forms of evidence. And we'll go over what those evidence forms are. First, there's physical evidence. An object or an item that you can touch, you can pick up, feel, see, handle, such as the actual headliner that came out of that album. We have that in physical evidence for you to have in the jury room. We have the seat in which Lacambria Toomer was killed. That's in physical evidence. Those are objects of physical evidence. That's one form of evidence. Another form of evidence is documentary evidence. Documents or things that have, because of their recordings, because of their content, have significance and value for your evaluation of evidence. That would include videotapes. It would include the audio tapes, photographs. All of that is documentary evidence. Even waiver forms, all of that is documented. Documents because of things that they have because of what they have in recordings. Recording of statements of witnesses, such as the recording of Kevin Davis' statement. All of that is documentary evidence. That's documentary evidence that you have. So you have that form of evidence. The next form of evidence is demonstrative evidence. Demonstrative evidence are things used to demonstrate, to make things understandable for you as a jury, so you can understand principles of evaluation, principles of the investigation, scientific principles. All these things are demonstrative evidence that you have, that you were using in the course of this trial. And then the next form of evidence, ladies and gentlemen, is testimonial evidence. Testimony that came from that witness stand. Testimony, words that came out of the mouths of the witnesses that was presented to you and recorded in this particular case. Testimony. Testimony is evidence just like the other forms of evidence I've just described. Testimonial evidence. And ladies and gentlemen, testimony is what each witness heard, saw, did. All of that is testimonial evidence. And ladies and gentlemen, the testimony of any one witness, if believed by you, can establish a fact. The testimony of any one witness, if believed by you, can establish a fact. And that is the law. And the judge is going to give you further instructions about all of the things I've just said. Further instructions about all of these things I've just described. And one other aspect of evidence is that it is divided into two general forms. One form is direct evidence, and one form is circumstantial evidence. Direct and circumstantial evidence are the two forms of evidence that you as a jury consider. Now, when we talk about direct evidence is something that goes directly to a fact. It directly goes to what is being asked. It could be, Mr. Jones says, I saw Mr. Jones shoot Mr. Smith. I saw this. This is what I saw. That's direct evidence going directly to a fact. Or even a recording that goes directly to a fact. So that's direct evidence. That's pretty straightforward in your understanding of how you evaluate evidence. Direct evidence is directly going to an issue. And if that direct evidence comes directly from an eyewitness or a witness that you hear in this trial, if you believe it, it establishes a fact. And you can rely on that as fact if you choose to believe that witness. And I'm going to talk about that a little bit more in a moment. The next form of evidence is circumstantial evidence. And circumstantial evidence, I'm going to explain it this way, is basically using facts to further develop facts to reach conclusions. Facts that will reasonably infer another conclusion. Putting together multiple facts and reaching a conclusion. You use circumstantial evidence every day. You use it all the time. It's not a mysterious concept. And the judge is going to explain it to you a little bit more. Circumstantial evidence and the weight and significance given to either form of evidence, be it circumstantial evidence or direct evidence, is up to you. Talking a little bit more about circumstantial evidence. Circumstantial evidence is basically putting together facts and then combining them with your common observation, common experience, common knowledge, and common sense. Common sense, ladies and gentlemen. Putting those things together. That's what you do when you put together things, and you need to consider all of the evidence, all of the circumstances, all of the situation when you're evaluating the totality of the case. That's what you'll be doing, using circumstantial evidence. And the judge, again, will give you these instructions about using circumstantial evidence. And again, the weight that you give to either aspect of it is up to you. And there's no distinction between the use of direct evidence or circumstantial evidence. So, ladies and gentlemen, you have direct and circumstantial evidence in this case. And moving on further, circumstantial evidence can be based on all of the forms of evidence that I've already described. It's based on physical evidence, documentary evidence, demonstrative evidence, testimony. You add them together with your common knowledge, common observation, common experience, and common sense. Common sense. You put those things together and you're using circumstantial evidence. And in this case, you have those forms of evidence plus your common knowledge, common observation, common experience, and common sense that you're using to make a decision in this case. And your decision should be that this defendant, Ryan Cooper, is guilty. Now, what we will move on to is really what you do in evidence. What you do in evidence is you weigh the evidence. And the weight that you give to evidence, that's what you do. You weigh evidence. That's what you do. And you've been weighing this evidence as you've been listening to this case. You've been weighing the evidence. You've been looking at everything, and you're going to come together at the end of this presentation of what we believe the evidence has shown you, and you're going to return the verdict that speaks the truth, that Ryan Cooper is guilty for the enormous crimes that he has committed. So ladies and gentlemen, as we move forward, I want to move to the issue of the thing is that what are the burdens here? The state has the burden of proof. It's up to the state to present the evidence in all the forms that we have just discussed. The state must bring you this evidence, and we brought you this evidence. We brought you this evidence. It's right here before you. It's in the witness stand. We brought you that evidence. You have overwhelming evidence. There should be no doubt in your mind at this point that Ryan Cooper is guilty. Should be no doubt in your mind. Now, the defense has no burden of proof whatsoever. They don't have to prove anything. They can say and argue whatever they want to say and argue. They have no proof, no burden of proof. And they can say and argue whatever they want. But the state has the burden, and we brought you the evidence because that's our burden. We brought you the burden, we brought you the proof in this case. And ladies and gentlemen, the evidence in this case is pretty straightforward. And there's some particular things I want to talk about right now about what we've already shown you. Number one, we've shown you that this defendant killed Lacambria Toomer in Doherty County. The circumstantial evidence that you heard will include that the notion that she's last seen alive in Terrell County. You heard evidence to that effect. You heard it from Catherine Hall. You heard it from Tevin Davis. She's alive, going down the road screaming. Why? Who knows what he was telling her in that car? The next county she's in is in Doherty County. That's shown to you by the evidence that came from GPS, phone records. The last living action related to Lacambria Toomer was in Doherty County. The last living action was using her phone in Doherty County. Chris County is only mentioned because of him. He says Chris County. But there's no evidence she ever made it to Chris County. No evidence she made it to Chris County. So the circumstantial evidence, alive in Terrell County, not alive in Chris County, alive at least a short while in Doherty County. And that is showing you circumstantially that she was killed in Doherty County. So the issue of venue, which is one of the issues that you are considering for this case, is settled by circumstantial evidence that you have seen in this case. defendant is guilty, and you heard direct evidence. Right out of his mouth, right out of the mouth of his best friend forever. He shot her. And not only did he shoot her, perhaps to make it clear, I mean what I said. Look up here. Look at this. To show he wasn't kidding. He wasn't playing around. He meant business. And what do you have in evidence? You have that headline that Kevin Davis said that he pointed to when he told him he shot. Why? Again, show that he wasn't kidding. To show the enormity of his crime, that he was telling Tevin Davis what happened. Tevin Davis is corroborating. Direct evidence is blood and other materials that you have here in this courtroom, right here, to corroborate that Tevin Davis was telling the truth. So that point is established. The other point that's established is that it's Lacambria Toomer's body, pieces of a body anyway, that you have in this courtroom. You heard that from the witnesses that told you that the DNA shows that the DNA only could have come from a child of Melissa Caldwell, Melissa Thornton. Only her child. She had two children, a boy and a girl. Only the boy is alive. The evidence is overwhelming that it's Lacambria Toomer's body, her blood, her DNA. So she's identified. She's identified scientifically. You have that evidence. There should be no doubt in your mind about that. So, ladies and gentlemen, that point is established with the evidence. So the main points: where it happened, who did it, and who was the victim, are shown directly to you and with circumstantial evidence. That's why at this point, you should hold this defendant absolutely 100% guilty of these charges. We're going to talk about these points further during the course of our presentation. But you already have that. And I wanted to just let you have that before you, again, whatever the defense may say, if they choose to say anything, if they choose to, they don't have to do anything. But if they do, these undoubtable facts are here. So, ladies and gentlemen, again, other aspects of evidence. One of the things is that there may be some argument about, well, some blood was not confirmed. Now let's look at what the law is and, well, actually what the evidence is. You heard from 3 persons about this evidence on this chair, this evidence on this headliner, the evidence on the console. You got a doctor who is a doctor and pathologist who's done thousands of autopsies, visited thousands of perhaps crime scenes, taught other scientists and doctors. He says that I got blood in my body. This is blood. You got a crime scene constructionist who had 63 years of visiting thousands of crime scenes, evaluating blood, teaching our national law enforcement organizations how to evaluate blood. He says it's blood. You got a forensic biologist who came in, the one who identified the DNA, as being Lacambria Toomer. She says it's blood. Your common sense, your common experience, your common knowledge, everybody has bled. Everybody's seen blood. This is blood in these objects. There's no doubt about that. So any argument, any suggestion that is not proven, that's just a specious argument. It's argument. Of course, anything that can be tested, you can test it over and over and over again, but why? It costs money to do all these extra tests. I think the argument was that the GBI doesn't do more confirmation tests. Well, why do more confirmation tests when everybody can see with their own other experimental methods that this is blood? So it's a financial thing, I suspect. But why do all of that when you have all of this evidence? And in this case, you have overwhelming evidence. The pathologist says, beyond a reasonable doubt, this is blood. And again, any witness that you believe is sufficient to establish a fact. And the judge is going to give you instructions on how to evaluate all witnesses, including expert witnesses, about their testimony. So that testimony, there should be no issues in your mind about whether that blood, that missing blood that was found in that vehicle was caused by this offender. Right here, Ryan Cooper. Look at it. He did. Don't let him hide the enormity of his crimes. Don't let him think that by erasing the existence of Lacambria that you all will be in any way hesitant in returning verdicts of guilt as to all counts. Another thing is that, well, he may argue, if he chooses to argue, he doesn't have to, that, well how did he get all that body weight out of his vehicle? You heard about the weight of Lacambria. And again, your circumstantial evidence is pretty clear. As testimony came out, it wouldn't be nothing to just kick her out, push her out the door. And you have actually in evidence, you have photographs of the Audi covered in plastic, showing circumstantially that he had access to plastic. He's a truck driver. He has access to hand trucks. Kick her out the car onto the hand truck. She's dead. Just kick her out. Move her around like you need to. Onto the hand truck. It's been our common observation and common experience that truck drivers, people who load and unload trucks, have hand trucks. That's your common observation, common experience. So, manipulating Lacambria's body was no obstacle. That's shown circumstantially. Throw on some plastic. He had plastic. That's shown circumstantially. He had plastic. He had access to these things. The plastic is seen in a photograph that you have here in evidence. So he had the means to do that. He had the means to manipulate Lacambria's body. So that's not an issue for you to even think it's not possible. All these things have been shown by direct and circumstantial evidence. She could be anywhere. He comprehensively hid her body. He had time to do it. He had the whole state of Georgia to do it in. He's a truck driver. She could be anywhere from on Centennial Drive here in Albany, Georgia, where the vehicle was, to somewhere near Savannah. We don't know. He might know. He does know. But he chose to erase the very existence of Lacambria Toomer. So, ladies and gentlemen, we're going to talk further about these issues in the state's case. But right now, you already have that information. You have overwhelming evidence to find Ryan Cooper guilty. And I want to move now into the crimes that are here. And we're going to talk about the crimes and the law that we apply to these crimes as the basis for you returning your verdicts. Now, we're going to start with malice murder. Malice murder is the intentional taking of a person's life, a human being. Lacambria Toomer was a human being. The intentional taking with malice aforethought. And malice aforethought, and the judge will give you the complete definition of murder. I want you to wrap your head around the issue of malice. Malice does not mean ill will or hatred. It doesn't mean that you're evil. It doesn't necessarily mean that you're cruel, but it is a cruelty that was done here. Cruelty. Malice means an intent to do an intentional act. And by way of just another example, so that you show that malice is not necessarily an act based upon cruelty. I mean, well, here's an example. A hitman is hired to go kill somebody. Hitman doesn't know this person at all, but he does it for money. He goes, he's given the contract, he goes, kills the person. May not know the person, but that's malice murder because it was an intentional killing. He doesn't know the person. He had no ill will or hatred to the person, but that would be malice murder because it was an intentional killing. Now, the other thing about malice murder is that the state does not have to prove motive. Motive is not an element of murder. We can't look into the mind of any defendant and decide whether or not why they did what they did. You've heard a couple of things about what was going on. There was something about, Lacambria might have done something to offend Ryan. It was boiling in his mind. We do know on that August 15th evening, they had an argument about, I guess he felt like she was showing out or whatever because he was asking for food, trying to get some water. maybe looked on his telephone. Maybe that had him mad. But we don't have to speculate about that because the law does not require the state to prove that. Whatever it is, he intentionally reached over that passenger seat in that Audi and shot her in the head. That was intentional. An intentional act. And that is sufficient for malice murder. Whatever was on his mind about why he did it. It's the intentional act that constitutes malice murder. So this defendant, Ryan Cooper, is guilty of malice murder. The next crime is aggravated assault. Aggravated assault basically is placing anyone in apprehension of receiving bodily injury. Immediately receiving bodily injury. And the other aspect of aggravated assault is of assault. Aggravated assault comes about when you assault somebody with the intent to rob, rape, or murder, or with a deadly weapon. Those are the ways that you can commit aggravated assault. And that's what happened here. And in this instance, Ryan Cooper made the assault with a deadly weapon. He made the assault with a handgun. And we know from direct evidence that he had a gun. You heard from Catherine Hall, yeah, he got a Glock. You heard from Kevin Day, yeah, he got a Glock. The Glock has disappeared. But he had one. He was armed. Kept it in that console. You heard that evidence. So he had a gun. A gun was used. All of the evidence that you heard about the forensics, a copper map, copper jacket projectile, ballistic mist, all of that shows a gun was used. All of that is in evidence. There should be no doubt in your mind about him killing Lacambria Toomer with the gun. And that's the basis for the aggravated assault. We move now to aggravated battery. An aggravated battery is essentially causing disfigurement to the body of a person. Causing disfigurement. And you heard the testimony from Dr. Downs that this wound would have caused her body to be disfigured, her skull fractured, her face sunken. That's disfigurement. You've heard that evidence. That would have been caused by the wound that was inflicted on Lacambria Toomer. That evidence comes from testimony from the pathologist. So you have a basis for finding the defendant guilty of aggravated battery because of the disfigurement that he imposed upon Lacambria Toomer. Now, for the purpose of felony murder, and felony murder is this. To begin with, aggravated assault and aggravated battery are both felonies. For consideration of felony murder, aggravated battery and aggravated assault are felonies. So what is felony murder? Felony murder occurs whenever somebody kills somebody while in the commission of a felony. When you're committing a felony against somebody and somebody dies, that's going to be felony murder. It can be without actually intent to murder. You might intend to just scare them. You might intend to just intimidate them. But if you do something that causes the death, that's going to be felony murder. That's going to be felony murder. And it does not require intent, does not require motive. Felony murder is found when a person kills somebody while in the commission of a felony. We got 2 felonies involved in this case. 2 felonies, aggravated assault and aggravated battery. So you have a basis for finding this defendant, Ryan Cooper, guilty of felony murder. Now I want you to wrap your heads around this concept. Can you have multiple ways of committing murder and felony murder? Yes. Did you have it in this case? Yes. Should you find him guilty of each form? Yes. So wrap your head around that, because that is the law. Murder and felony murder were all committed in these various ways. And you are authorized, and you should find him guilty for each and every form of murder that he inflicted upon Lacambria Toomer. So wrap your head around that, because that's the law. And your verdict should find him guilty of each form of murder. There are multiple counts of felony murder, 2 counts. And he's guilty of both forms of felony murder and malice murder, as well as the felonies themselves, the aggravated assault and the aggravated battery. Don't lose sight of that. That's the law. You can find him guilty, and you should find him guilty, because he committed murder in all these different forms. In all these different forms. The next crime that he committed was the crime of possession of a firearm during the commission of a felony. And in this instance, he had a firearm. Was it that Glock that we know was in his car? Circumstantial evidence suggests yes. The Glock that he always carried? Yes. Was it within arm's reach of his person? Yes, he had to have it in his hand when he reached over to the passenger seat and shot Lacambria Toomer in the head. So it was within arm's reach. Circumstantial evidence shows you that. The circumstantial evidence, direct evidence, is that the spray is consistent with someone in the driver's seat reaching over and shooting someone in the passenger seat. That's the evidence you got in the courtroom. That headline. You've got the evidence for that. The evidence for that is here in the courtroom. So you should find him guilty of possession of a firearm during the commission of a crime. Now, the important thing about a couple of these things is this. The actual recovery of the gun is not required under the law. You're not going to be heard by the judge, not going to instruct you that you have to find that the gun was recovered. That's not the law. Even with the murders, you don't have to find that the body was recovered. That's not the law. The law does not require that the body of Lacambria Toomer be found and presented in this courtroom. The law does not require that the gun that was used to kill her be found and presented in this courtroom. If you have all the other evidence that you have indicating these crimes were committed, which you have, overwhelmingly, without a doubt. And ladies and gentlemen, the last count that's involved with this defendant is concealing the death of another. Concealing the death of another. And he has comprehensively hidden Lacambria. At the start of the case, The question was, well, where is Lacambria? Well, she's right here. Right here. Right down there in front of you. Some of her anyway. She's right here in the courtroom. She's going to go back with you in the jury room. She's right here. Part of her anyway. We don't have all of her. And that's what makes this crime so enormous. The little boy that was born of their relationship, the existence of his mother is taken. The existence of her is erased. That's the enormity of what he did. That's the enormity of what he did in this case. And please, 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 do not let him even remotely believe he's getting away with it. Don't let him get away with anything. Don't let him get away with anything. This defendant is guilty of each and every charge in the indictment. And that's the verdict we ask that you return. He's guilty of each and every count. Each and every count is supported by both the law and the facts and y'all's sense of what is true and justice. Now, we've been in this trial for, I guess, over a week. But truly, you should not be reluctant to quickly return a verdict of guilt on all these counts. Because the evidence is overwhelming. Don't be reluctant in quickly telling him, Ryan Cooper, you didn't erase Lacambria. She's here. Ryan Cooper, you're guilty of everything that you did in the dark that has come to light. Ryan Cooper, you're guilty of each and every count because that is the verdict that speaks the truth. You have overwhelming evidence in all the forms that we've just discussed indicating that this defendant is guilty. And we ask, after you have heard all of the further proceedings in this matter, that you return this verdict of guilt against that defendant. Your Honor, that completes the state's first argument.
Thank you, Mr. Edwards. Mr. Davis, do you want the jury to have a stretch break before you start, or?
Judge, I'll leave that to the court.
Y'all need a stretch break before you start? Excuse me? Are you good? It may go for an extended period. I'll let you call it, Mr. Davis.
Yes, Your Honor. Good morning, ladies and gentlemen of the jury. In leaving you today, I want to begin by saying that no lawyer has ever had a better jury. And as I sat from over there and had the occasion to watch you, I noticed that you were paying attention and taking notes, if not writing them, at least taking mental notes on what was going on. I know that this has been an inconvenience, and on behalf of Ryan, let me be the first to say thank you for your participation. It's a pretty interesting case, don't you think? This case had reached a point where the investigation had come to a stall. When Mr. Cooper was not indicted, what pushed the DA's office to the indictment in March 11th of this year was him bringing in the people that he paid to make incorrect statements. Now, the most unusual thing about bringing in this expert from Oregon is that he was infamous in terms of what he told jurors, the truth of it, and a very famous person, or a very famous case in which an innocent man had been convicted because he took the stand and he told them that he knew without any doubt that that defendant had to be the person that killed his wife. That's just like he took the witness stand here. It's almost like a replay of time. He gave almost the exact same testimony. The really heartbreaking thing is that what that expert did was he stopped the investigation, because when they focused on the husband, relying on his testimony, they stopped investigating the case. Now later on it was discovered that there was some DNA on his wife that linked to the actual perpetrator. Mr. Engler, who had sent a photographer to take pictures, who had impersonated a scientist, Mr. Engler's employee, who later admitted that he perjured himself, testified for the defense in the third trial. He almost had to do that to keep himself from getting prosecuted. So there was no doubt about the fact that this man has absolutely no credibility. And it was for that reason he was talking. He didn't realize I had any paperwork. And as soon as I showed him a copy of the paperwork, he stopped talking. He stopped talking. So this case, what is this case really about? This case is about jumping to a conclusion, not doing all that you need to do to investigate a crime. I need the screen turned on, Your Honor. Okay. So what I want to do at this point is just go through the testing that was done, because a lot has been made of the chair and the blood that was found around the chair. Remember that? The blood was flowing onto the chair, off the chair, to the left, through the center console, onto the floor. So all of that was tested. All that was sent to the lab. Now I do want to point something out, that even if you believe it's blood that's under the seat, behind the seat, in that area, all these other places. That blood was never tested and confirmed to be the blood of Ms. Toomer. There was no DNA testing on that. The only DNA testing was on the headliner that was part of the convertible roof. That was it. There was no testing from any other substance in the car or anywhere else that came back to Ms. Toomer's DNA. All right, so let's talk about the very first report. The thing to keep in mind is this. The very first time that the car had been searched, all items had been sent to the crime lab. Whenever they wanted to submit, all that came back as not the scientific definition of blood. All right? In fact, these results were inconclusive. So let's talk about what we're talking about. And I want to begin with the 1A here. That's the passenger's door interior. You remember the last expert said there was blood on the door. Remember, he said there was blood on the door. All right? So the very first test, passenger's door interior, this is what was submitted. Passenger's door interior wet, passenger's door interior dry. Front passenger side between the seat and the frame swabs. So what I'm trying to do here is direct you to what was actually looked at and not just make a vague reference to it, because this clears up a lot. All right. So they're testing, if this is the seat, they're testing all of this. All right. And this is not the actual chair, by the way. They're testing all of this on the side, on both sides, and to the back. Everything surrounding that chair, they're testing under the chair. All right, so when we talk about front passenger side between the seat and the frame, that's this side, right, between the seat here and the frame. Tested that. They tested it with a wet and with a dry. What they do is they wet the Q-tip and they take a sample. And then they take a sample where it's not wetted, dry. So they took 2 different samples from that area. They also, now here is something that's very unusual. They also took samples of the headliner. So the last thing you're going to see when you get this report, which is one of the state's exhibits, is you're going to see here passenger roof liner dry, roof liner wet. That's what you're going to see when you get to see the actual report. So passenger roof liner dry, passenger roof liner wet. All right, and here are the results that say at the chemical examination. These are the particular items, the swabs, everything that was introduced. That came back as inconclusive for presence of blood. Now, it's inconclusive because they're getting 2 different results. And you see the 2 presumptive tests for blood did not produce the same result. And the reason you can get different results with a presumptive test is that's not really a scientific test. The definition of science is to reproduce a result reliably. This is not science. That's why you're getting a positive and a negative. They didn't do a confirmation test. So she got 2 different results. No one should even be referring to that as blood. no right-thinking police officer, attorney that works in this space, nobody should be in front of a jury telling a jury that's blood, because that's misleading. These tests are just to help you in your investigation, to show you what to consider on. So no one should be doing that. That's how that man got found guilty of something he didn't do after Ron Engler came down there and said some of the same things he was saying here. You have a presumptive test, then you have a confirmatory test, and then when I pointed out to him, no confirmatory test was done here, he thought that. He said, yeah, I think a confirmatory test was done here. I said, no. I said, actually, the testimony we got is a GBI don't do confirmatory test. Oh, that can't be true, et cetera, et cetera, et cetera. But in any event, he assumed that he had neither a presumptive test or a confirmatory test, and then they went to, oh, I can tell his blood by looking at it. None of these experts had ever said that. Not him, not the other paid expert who works at the UPS store. None of them had said, I can tell his blood by just looking at the blood. All right, well, how can you tell it's Ms. Toomer's blood? Because presumably you would need to test that for DNA. So that's ridiculous. You can't tell that whatever they were looking at was one, blood, and two, Ms. Toomer's blood. We also know that because the investigator who was using luminol, this is the area he's using luminol, all came back negative. And you remember that the only presumptive test he got initially was between the seat, the rear seat, and that was it. So the luminol test was negative. And the test he got back from the GBI, all that's negative. The last sentence in the report is 1A02 fails to reveal the presence of blood. Now it was clear from what Ms. Folks said that fails to reveal means it's actually negative. It's actually negative for the presence of blood. So let's take a quick look at what was 1A02. All right, so 1A02 is the passenger door interior. That's 1A02. So if we knew nothing else from the testing, we knew that the passenger door actually tested negative. Was no question about that. Negative for the presence of blood. So I don't know why this expert would have come in here and said there was blood on the passenger door. There was no blood on the passenger door. There was no question that the passenger door tested negative. So that's the first test. There are only two tests for blood. That's this January test that I'm showing you now, and then the other test is in April. So let's take a look at the April report. All right, so the first thing I want to show you is that there was a sample taken of item 05B, and 05B is a wet, dry swab that was taken underneath the passenger seat. Underneath the passenger seat. That is 05B. All right? And what she said about 05B is the chemical examination of the swabs from item 5B and that's under the seat, and the stains from the piece of front passenger seat. All right, so here they're testing underneath the seat. They're also testing a piece of the front passenger seat. That was the cushion. Both of those failed to reveal the presence of blood, which means they were negative. which means that when they pull the seat out, this tested negative. This hole they have here, when they pull that out and they got the cushion, that tested negative for blood. Now you'll remember in item 6, she did say that there was the presence of blood on the same item number 6, but then she explained that the leather portion, there may have been the presence, but underneath the leather portion, that tested negative for blood. So there's no question that there is no blood in the cushion of any car seat. That specifically came back negative. So why they have the car seat up here and the cushions pulled out, and they're trying to tell you that those cushions that was blood, that's not true. And you'll have the test to look at it for yourself. That wasn't even a presumptive test about the cushion that they keep talking about was soaked in blood. The cushion is what the medical examiner is basing his testimony that she died in the car, because from the cushions he could determine the number of liters of blood that she lost. That was based on the cushions, that's based on their experiments with horses. That's how they got that. Now all that's junk science, all that makes no sense. But in these cases, it's in these details where you catch them, or where you don't. And when you don't, what happened is the same thing that happened with the person who got convicted and spent 13 years in jail. Now, it meant nothing to Mr. England. He still ain't remorseful. Oh, he sued 30 people, etc., etc., etc. He didn't say, my case got dismissed. I didn't pay him a penny. And if he hadn't paid him, he's the type to be the first to say, I never paid him a dime. What he said? Oh, I can't talk about it. He was quick to bring up the fact that he can't talk about it. He could have said, I ain't do anything then, I ain't do anything now, I never paid anybody. Why would he, unless he had agreed not to speak, why would he be prohibited from talking? He ain't prohibited from talking. He's only prohibited because he entered into some kind of agreement admitting his guilt, because he was guilty. And he knew it. He's still down here defending the man who took the stand and said, I perjured myself. He was still down here defending his employee, talking about his employee did a good job. The man was never trained as a forensic biologist. He was never trained in crime scene investigation. But Mr. English still defended him. You know why? That's what he gets paid to do. He does not charge a flat fee. He gets paid by the hour. You submit to him a case and say, what do you think about this, Rod? If he says the guy is innocent, you know his total fee is $575. That may be split up depending on how quickly he reached that conclusion. So he only gets paid if he extends his, whatever he's doing, whatever he calls it, flies down here, gives testimony. Because he's charging by the hour. So when I asked him, hey, what is the total bill? He said, oh, I don't have it yet. I'm still charging. I'm still charging. Right? He testified on Monday. He testified on Monday in this case. On Monday, we had maybe one or two brief witnesses. Got him pretty quick, remember? Now last week, Y'all had to sit through a 2-hour video. Remember that? Remember, you couldn't go home on Friday because you had to sit here for 2 hours, right? That's because Ron can't get down here to Monday. So they're playing for 2 hours, torturing everybody in the room, a video, the audio of an interview, when the man had already testified. He had already testified. The officer had already testified as to what he said. They ain't played just the portion they needed. They just took 2 hours, and after that 2 hours, you then went home. So Ron was also eating up part of your life as you are about to make a serious decision. Because Ron can't fly in until Monday. Ron can't fly in until Monday. The reason the photographer was mistaken for Ron is because Ron wouldn't go to the crime scene in that case. He sent the photographer in his stead. Ron had come down here to look at nothing but pictures. He said it's the second time down here. It was the second time down here. Same for the other expert, so-called expert. Now you may be asking yourself, it's pretty expensive to prosecute people. Why is it expensive for the state to prosecute people? The state has the Georgia Bureau of Investigations. They could get those experts for free if they're willing to give that testimony. He went outside the system because he couldn't get anybody else to come in and make those claims. That's why you have private experts testifying in a public trial. Because Mr. Edwards decided to use taxpayer money to do something that he couldn't get done through the GBI. You know why? Because this stuff wasn't adding up. That's why. But there's no slowing Mr. Edwards down. When he got his mind made up, there's no slowing him down. There's no slowing him down. It's skipping steps. We know he's guilty. We ain't gonna do it. Even Ron English said, you gotta have a confirmatory test. No, but ain't no slowing him down. It's the officer saying on the witness stand, hey, wait a minute. We're still looking. We ain't got no certificate of death. We don't have all these other things. Well, officer, let me ask you this. What day did she die on? I don't know. Now, does it sound like Mr. Edwards is listening to the people who have been investigating the case from the very beginning, or taking it into his own hands? That's exactly what he was doing. She's saying that she doesn't know because she doesn't know. The whole case, the whole theory of the case makes no sense if you think about it. They had this boy the whole day. They had him using the car on video. They even have him using the car at 8 o'clock that night. Now, they haven't come back to emphasize that. Once I pointed out, what was the window for him to kill her in? They had him using the car at 8 o'clock that night. They knew exactly where he was at. Remember, after I asked about GPS and being able to track somebody's phone, they said, oh, you can be anywhere. You can be anywhere in Albany. When they put the slides up, he went anywhere. You could see the street address. You can see his exact location. They talk about everything except for how the crime actually happened. We spent most of the trial just trying to get the blood straight. Even if you believe it's blood, they never proved that it's the blood of Miss Toomer. There's no DNA matching on whatever they claim they were looking at, that none of the tests confirmed. The only DNA matching is up above. It was a very small amount. If you want to call it blood, so be it. A very small amount of some fluid that was in the headliner that matched a woman who rode in that car all the time. That matched a woman, if you look at the little incident they got into, she was bleeding that day when they got into that fight. It certainly is not enough for you to jump to the conclusion that Ms. Toomer was shot to death in a small vehicle, with there being no gunshot powder residue anywhere. When you fire a gun, one of the things that comes out as that bullet is traveling are particles, and these particles are part of gunshot residue. That gets trapped into fabric, into clothing. They found absolutely no gunshot powder residue, but that didn't stop it. Getting back to how he committed the crime, if you take into consideration at 8 o'clock he's in a store using Ms. Toomer's card again, then he either committed the murder before he went into the store or after he left, but before he went to work that night. So they left Dawson, I think, the officer said around 4 o'clock, 6 o'clock, to get back to Albany as he's preparing to go to work. So if you believe he killed her during that time, he has to shoot, kill her, then dispose of the body. The body, according to them, is just pushed out of the car. You will still be able to track the car off the road to wherever he presumably dug a grave, buried her inside, and covered it over where no one was able to find it. It is completely bizarre. This is completely a work of fiction with no happy ending. That's not the way, if there was a way, to get away with murder. This is something that would come from a television show. They have him in the middle of town when he gets back. That's confirmed by their own cell phone mapping. They have him, if you believe he killed her at some point after he left the store, killing her in the middle of town, not in some secluded area outside of town. The timeline doesn't work. If you look at the time and the location where he was at, there's no way that he killed this woman during the time that they say. That's why the officer said, I don't know. In the indictment, it says she died on August the 15th. I'm sure they may come back up here now that I've said it and try to say, hey, look, you don't have to find that she died on August the 15th. Well, they owe some investigation to you, ladies and gentlemen of the jury. They're putting the case to you now as though you could investigate this case from the jury box, which you cannot do. You can't issue subpoenas. You can't interrogate witnesses. They're asking you to do something that they couldn't do. Since the disappearance of Ms. Toomer, they haven't been able to find her. They claim that she died. I get that. But it took them an enormous amount of time to reach that decision and ultimately to get these experts. And they still haven't figured it out. Their case makes absolutely no sense. And it didn't start making sense because a man who was in jail in Terrell County did what every prisoner in jail does, which is he tries to get out of jail. They try to get out of jail by implicating somebody. The somebody to implicate obviously was Ryan Cooper, because the officer had come to talk to him on 2 prior occasions. He realized that he was valuable, and that's why he made up this story on Ryan Cooper. There has been no one to come in here and say they found brain matter in the roof. That was completely ridiculous. They're saying that his being in jail has nothing to do with this case. I grant you that. That's not the point. His wanting to get out of jail has something to do with this case. His wanting to get out of jail has something to do with this case. And he wants to use Ryan to do that, so he can get out of the prison that he got himself into. He can get out of the prison that he got himself into. What the state is asking is that you essentially help him get out of jail. That you essentially help them prosecute cases like this in the future, which not only would take away the life of an innocent young boy, but also cost taxpayers an enormous amount of money. The tab they'll ultimately get for using these private, whatever you call them, maybe $50,000, $60,000, or $70,000. The services they provided to the district attorney's office was free. The GBI gives the same testimony. Only if it's warranted, though. You can't get them on the case. You can't use the medical examiner to claim that someone died and to give a cause of death when they have no facts to rely on and they disagree with you. That's why there was no medical examiner from the state of Georgia called to testify. They don't explain that. Why didn't their own medical examiner call this a homicide? Why did they have to go and get someone who worked out of the UPS store and lives in South Carolina to come down here and, according to him, give an opinion that is so obvious that anyone in his field could see it? Like, I've been doing this for 30 years. I can tell DNA on sight. Well, if it's that obvious, then why didn't someone from the state's medical office sign off on it? Sound like it's routine if you listen to him. He got to stand, he sounded so confident. Different than what he put in his cut and paste letter. When he was saying, you know, all of my observations, everything I'm telling you is dependent on actually examining the body. Him and Mr. Engler are nothing more than snake oil salesmen. They come to town, they tell you what you want to hear, they give you something that makes you feel good, and they make you think that they are exercising some kind of expertise, in which they're not. All these men were doing was getting paid and trying to secure a position in the Dory County District Attorney's Office where they could get paid in the future. Because one of the things you could take from the way they testify is that they want to come back to give the same kind of testimony, to pick up another check. That's why he was down here. That's why he was down here. This is a tragedy not only because we have the disappearance of someone and we don't know why, but also because the state wants this young boy to pay for a crime that they never investigated, that they have ignored all the signs that point away from his guilt. And I would just ask that we not compound one tragedy with another. Thank you very much.
Thank you, Mr. Davis. Ladies and gentlemen, it is appropriate that we take a 15-minute break at this time, so I'll see you back at 5 till 11.
Where is Lacambria Toomer? That's what I asked y'all. That's what I posed y'all when I opened last week. Where is Lacambria Toomer? Lacambria Toomer is in that seat cushion. Lacambria Toomer is in that console. Lacambria Toomer is on that headliner that was above her head when the defendant shot her in the head. And today, I'm going to ask you to bring Lacambria Toomer home. And I'm going to ask you to find the defendant, Ryan Cooper, guilty as he is on each and every count. Now, before we get to the real case here, I want to address a few things that the defense pointed out. I want to go ahead and get that out of the way so we can actually get to the evidence and the facts of this case. The defense says, well, our investigation came to a stall, so we had to go get some paid experts. The investigation had not come to a stall. The investigation started with her mother, Melissa, reporting her missing on August 24th, 2022. And it continued daily, weekly, monthly, yearly. Investigator Calandria Peterson told you last week, this investigation ain't ended. We ain't found Cam. This investigation has not ended. We didn't need paid experts. We knew what happened to Cam. We don't need paid experts to try to bolster some case that's not there because it's there. They want to say, well, they didn't confirm this, they didn't confirm that. Why do you think when we found out that he shot her in the head, why do you think when we found out what happened, we had to go get experts to confirm that, to further the investigation? And then they want to talk about, well, Mr. Engler in this David Cam case. We're not here because of a state trooper who was found guilty 2 times for killing his wife. We're not here because of David Cam. We're here because of Cam Toomer. We're here because of Cam Toomer. That's what we're here for. Jumping to conclusions. We're not jumping to any conclusion. This case has been thoroughly investigated to the best of their ability. Well, they didn't find this when they swabbed right here. You gotta understand, and y'all heard, this wasn't one search warrant on that white Audi that he killed her in. This was the initial search, where there was presumptive positive for blood. There was also some spots that weren't presumptive positive for blood on that first search. The first search, when nothing was moved around, no seats were taken out, none of that. This is a car that has been sitting there, had a window shattered out, elements have been coming in, dirt's in there, the duration. You're probably going to pick up all kinds of stuff on swabs. But they continued to search and they tore that car apart. They tore that car apart. And the three main areas where they found blood, both APD and the GBI. The GBI, right, that the defense mentioned, the GBI who told you her expert opinion it was blood. The defense is over here saying, why didn't they get the GBI? We did. She told you it's blood. Bianca Fox, biologist. She told you it's blood on the headliner. It's blood. My expert opinion. The test showed it's blood. It's blood on the seat. Oh, well, no blood's on the seat. Well, guess what? You got it right there. You got the fabric from the seat where the blood dripped down. What she said about item 6 was one side of the flap that's on the bottom of the seat, one side was positive, the other side wasn't. You got that right there. You got the console. Around the console tested positive. They're not going to keep testing every single thing. They've got 3 positives. And you know what else they got? They got her DNA on the roof of the car. They got her DNA. Her DNA. The child of Melissa Thornton. The only child Melissa Thornton has that is no longer alive. The only child that left in the car with Ryan Cooper screaming after he had drug her and I think Tevin said tussle with her. That child. They didn't get the GBI. They got paid. The GBI medical examiners do autopsies. That's what they do for our office, the district attorney's office. We don't have a complete body to do an autopsy on because this defendant hit her. He hit her. The medical examiners, that's what they do for us. They're not crime scene reconstructionists. They do autopsies on bodies. You know, and this person discredited this person, and it's just, he works out of the UPS store. Dr. Downs is a medical examiner for the state of South Carolina, but he's also a private consultant. That's why he's up here talking to y'all. That's why he's up here on the case, because of his private consultancy. You think they're going to get up here, either one of them, Englert or Downs, and lie? Englert with 60-something years experience. Downs, a current medical examiner, a medical doctor who's worked with the FBI Behavioral Analysis Unit, who's published a forensic book, and they had the same opinion about the blood as Bianca Fox. GBI. And then the defense says, well, no timeline. The timeline doesn't work. The timeline doesn't work. You're dead. Pull the trigger. You're dead. He was from Dawson to Albany. You're talking a span of 10 hours. You're talking a span of 10 hours. How do we know? Because we have the cell phone records. We have the cell phone records and we have the truck GPS records. The defense said, well, the cell phone record shows exactly where they're at. Well, first of all, that's not what the cell phone lady that testified said. And I think we all, with common sense, know that's not true. It tells you the area of the tower you're pinging off. It does not tell you you're at this person's at Walmart right now. We all know that. We all know that. We saw he was around in Albany. We saw he was over near Moultrie Road. He was all over the place in Albany. We don't know exactly where he's at. But if 10 hours ain't enough to shoot a person in the head, come on. We don't have to prove he hid the body in Albany. We don't know where he hid the body, but we know he hid it. We know he hid it because we know she's dead, and she died in his car. And then, well, Tevin tries to get out of jail. Well, let me ask you this. At the time they talk to Tevin, and Tevin gives the information about the window in Cooper's car, the defendant. Tevin gives you information about the headliner, describes it. I saw these little black, dark, reddish black dots, like when blood dries. He gives that information. Says he shot her. How does he know that before they've even broken the car down? Tevin tells that before we get all this. That's how we know Tevin's telling the truth. And he didn't get out of jail because he's right up here. He came right up here in his prison car. We're going to ask you to bring Cam home. To her mother, to her son, bring her home. Now let's talk about the real evidence in this case. What y'all heard and what y'all saw was a snippet of the defendant's violent behavior to Cam. And it's very important because all of this is the precursor to when he shot her. All of it. On July 17, 2021, if you'll remember, she runs up to an Anthony salon, Carolyn McLeod's salon. Let me in, let me in. She has a bra and one shoe, bleeding under her nose. Carolyn McLeod says, I thought of my own daughters and I let her in. So she says, I thought of my own daughters and I let her in. Carolyn McLeod said that she told her boyfriend was after her. But Carolyn McLeod saw that white Audi slowly driving by. She locks the door. She ain't letting nobody in. She told you that. I didn't let anybody in. Not even her own mother. Until the police get there. So some help gets there for this young lady. Not letting anybody in. And she saw Melissa getting out of the defendant's car. She sure wasn't letting her in. "911. Call comes in, pointing a gun at her. Who? Subject Ryan Cooper, pointing a gun at Cam. Pointing a gun at her. Pointing a gun. The defendant. EMS. What was the primary injury noted on that EMS report, the testimony from the aggravated assault incident in 2021 was an injury to the head. He's hitting her in the head. She even has a hematoma that was described in testimony as a goose egg, where he hit her. He probably hit her with that gun, that he always carries, that Glock that everybody's testified about, or either it's been put in some other way. And that she was in pain and distress, and that's what EMS Figueroa told you up there. That was her observation. She saw the hematoma, the goose egg on her head. Not only that, she had bruising on her body. There's a picture in evidence. There's actually two pictures in evidence. Bruise on her arm. So you heard from Officer Jarius Wilson, who was the responding officer to the salon that day. He detained the defendant. Remember, he said he put him down in prone position and detained him because of the firearm issue. Because this was a call that someone had a firearm pointing at Cam. And then he searches the defendant and he finds a magazine on him. Magazine on his person. He asked him about the gun. He reads the defendant his Miranda rights right there on scene. This is when we're still at the salon. Right there at the scene. Asked the defendant about this gun. And the defendant denied having a gun to Officer Jarius Wilson when he initially asked. Why did he do that? Because he's guilty of aggravated assault. Because he knows he pointed that gun at him. He denied having a gun. We know that's That's just not true. We know that the defendant left the salon, went to Melissa Thornton's house, went to Cam's mom's house, and told her, you heard from her, told her your daughter just jumped out of a moving car. And she told you what she's thinking, I gotta go see about my baby. I gotta go see about my baby. So she gets in that car. She goes and gets in the white Audi, the passenger seat. And what does the defendant do? Hold on, I gotta go put something inside. Hold on. Melissa told you that. Melissa also told you that when she finally could talk to Cam that day, when she got back to the scene, that the defendant, Ryan Cooper, had pointed a gun at her. He pointed a gun at me. Remember, because Melissa said my baby didn't look right. She didn't look right. She's bleeding under her nose. She didn't look right. And how do we know the defendant was lying about having a gun? Because he went and hid it in Melissa's house. You got the picture right there in evidence. That's Melissa's couch, and there's a gun right up under there. The gun is recovered. The gun is recovered, and the magazine that you see above the gun was actually in the gun. And the gun was loaded. The gun was ready. If you remember Officer Harris testifying about that, the gun was loaded, ready to be fired. One in the chamber asked her about that. It was ready. The gun that he pointed at Cam that day was ready to be fired. This gun he keeps in his car. And they search his car. They search his car, that same white Audi. They find additional ammunition. You know, he's got a magazine on him. He's got the gun he's hid. He's got additional ammunition. They find Cam's torn shirt. Torn shirt. Torn. Ripped down here. From a violent, her trying to get away from his violence. Jumping out of that car. Leaving her shoe there. Her purse there. Leaving it all there. Running for help to a salon. She didn't even know these people. She's knocking on the door. Let me in. And then the defendant, you know, Officer Wilson finally, before he gets, the defendant gets interviewed by Investigator Perry, Officer Wilson asked him on scene, come on man, I just got word, you put a gun, I know you stashed a gun in that house up there, Melissa's house, I know you stashed a gun. He finally admits it to Wilson after he lied. But then he goes and is interviewed by Perry. Now remember, Wilson's still at the police station, and he testified to that because he was the person transporting him. And when Investigator Perry's interviewing him and starts talking about her injuries, he laughs. He laughs! Y'all remember that? Even Wilson, who came to the door, I was like, I don't know what you think's funny about this. She has got a hematoma on her head. She's bleeding. She's half naked. And he thinks it's funny? He thinks it's funny. You saw it. You heard it? It's a fact. He thought it was funny. He could care less. Moving on. March 28, 2022. Gertrude Sanders, the neighbor of Melissa Thornton, goes and gets Melissa because Melissa needs to go over there to get Cam and the baby away from the defendant. Cam had called her mama, come get me. So Gertrude's the one providing the transportation for Melissa. When they get there, the defendant's outside in his white Audi. Cam is inside and the door's locked. So they can't get in. She's got the door locked, probably to protect herself from him getting in, although he has a key, because he comes and unlocks it. Gertrude testified. She said, Cam told me he's going to kill me. Gertrude said, I told her mom. Like she's warning Melissa about the situation, how serious it is. And Gertrude testifies that they're just trying to get the baby in Cam. Cam's baby, the baby she had. He may be the biological father. There's no evidence he's the legal father. I asked Melissa about that. Beating her. That's what Gertrude said, beating her. As she's leaving, going down that wooden steps from the trailer, beating her. To the point it knocked the baby on the ground. A newborn baby. You heard Melissa, I thought my grandbaby was gone. Not only Melissa, Gertrude told you how serious it is. She ran and got the baby. They got in the truck. But Gertrude also said that once Cam fell, that he walked over there to her. He walked over there to her. Kicked her. That's what she said. Stomped her. Now he thinks all this is funny, I guess, again. Kicked her and stomped her while she's on the ground. And when she gets up to defend herself, and yeah, I put in the pictures of this defendant with the marks that he had on him from her, the marks that he deserved, because the witness testimony is once that baby hits that ground and he's stomping on her, Cam gets up. She's had enough. He has messed with this baby. This baby could be injured. She gets up and fights back. And is he worried about little Jordan? Is he worried about little Jordan? No, he's not. Because you know what he does? When she starts fighting back, he gets his cell phone to record. Typical domestic violence. Get a reaction from you. Oh, now look at her, how bad she is. I asked Gertrude Sanders, did he record any timeouts? Did he record when he was beating her? Oh no, he just did it then. Yeah, they were both charged, but it's clear by the evidence who the victim was. The same person who was the victim a year prior when a gun was pointed to her head. And he busted her lip, and she had some other marks on her that y'all have the photos and that y'all saw prior. And then we get up to April 9th, 2022 after this. There's another incident. 4 months before he kills her.
911, what's the emergency?
Yes, can y'all send somebody to 3302 War Eagle Avenue?
Okay, give me the address again.
3302 War Eagle Avenue.
Okay, 3302 War Eagle.
Mm-hmm.
Okay, is this a house or an apartment?
It's a trail.
Okay, what's your phone number?
229 633 3126.
Okay, 229-633-3126.
Uh-huh.
Okay, what's your name?
My name is Andrew Simmons.
That's what you said, Simmons?
Yes.
Okay, what's going on?
Well, my niece just ran around to my house and her boyfriend jumped on her.
Okay, where this happen at?
At her boyfriend's apartment.
That's in the same area?
Yeah.
Okay, what's your niece's name?
Her name Cam.
Okay, Pam?
Cam.
Okay, where is she right now?
She at my house at 3302 War Eagle.
Okay, and the boyfriend lives on what street?
What name of that street he stay on? Eagle Court.
Okay, what's his name?
What's his name, baby? What his name is? Ryan Cooper? Oh, Ryan Cooper.
Ryan Cooper? Okay, is she injured, ma'am? Is she hurt or she was a paramedic or she's okay?
She okay, she just crying.
Okay, where is he at right now? Where's Ryan?
Ryan, he's still at home, I guess.
Does he have any weapons, you know of? Does he have any weapons?
He didn't have no weapon, did he? He was beating her with his hand.
Okay, well listen, they're being dispatched to you, ma'am. Give me a call back if anything does change, okay?
Okay.
All right.
And Andrew Simmons told you that she came there that evening with no shoes. She was crying. And Andrew said, and she was wet. And I asked, because I was like, well, thinking it was raining or something. I said, well, why was she wet? And she said it looked like she had wet herself. EMS testified the primary injury to her that day was her head. And I said, well, why do you have that on there? Head. He said, I have that on there because she said he was hitting her in the head. Her boyfriend was beating her, and she had visible bruising, he said. He could see that. I believe it was the left side of her face. The officer also saw the injuries on cam, the left side of her face, arm, and under her eye. That would be Officer McCrae. He saw the injuries. And Officer McCrae said, I went to the location to try to find the defendant because Cam, the victim in the case, had told me there was blood in the house. So I asked him, I said, well, when you went there, were you able to verify that blood? And he said, yes, he was. But the defendant was not there. And he took a warrant, and the defendant was not arrested until they found him in September due to Cam going missing. On August 24, 2022, Lacambria Toomer was reported missing. Her mom had seen her August 13, 2022 at the Walmart because Cam was going to go buying stuff for Jordan to give her mom, for her son to give the stuff to her mom. And when Cam got to the register, if you'll remember, she opens up her wallet to pay and her card's gone. Her card's not there. Well, we know where her card was. It was with the defendant. She spoke with Cam on the phone a little after that. And no further contact ever to her mom or to her son, which would have been through her mom. No video chat she used to do with her son. No presents for the holidays, Thanksgiving, Christmas, birthdays, nothing. Years and years, no contact with her mom. And you will remember Melissa said, when I asked, is that normal for her not to contact you? And she said, well, she testified about sometimes there might be a couple of weeks, but when was that? That was when she was on the truck with the defendant, and if she wasn't around Wi-Fi, she could not contact her. Her mother talked about her getting an iPad, which was never found, or some sort of tablet, tablet or pad so she could have more contact. But did she ever fall off the face of the earth? Absolutely not. Absolutely not. When she reported her missing, Officer Newberry testified that he put a be on the lookout. Be on the lookout. So everybody would know. That he ran it or put it in through NCIC. So she popped up, some kind of driver's license issue, or popped up somewhere all over the United States. NCIC. National. Reached out to contacts. Investigator Battle, who was the initial lead investigator on the case, testified. She searched a warrant of Cam's phone. She contacted the defendant's job. She got truck records. Social media, putting out missing pictures, photos, posters, reaching out to people on social media, contacts, locations, and she interviewed the defendant. And remember, she went out on maternity leave. And Melissa, at some point, contacts the police. You better look at him. You better look at the defendant. This is right after she initially reported her missing. And what does Melissa do, Cam's mom? She calls the defendant multiple times continuously. He won't answer the phone. Of course he won't. He just killed her daughter. That's why he answered his phone. She even had other people call from different numbers. He wasn't answering nobody. He wouldn't even talk to his parents, if you'll remember that, when they talked to him in his interview, battling them. Oh, you ain't been talking to your parents either, have you? You ain't been contacting them. No, well, not till I got arrested. Not till I got arrested. He had been avoiding his own family. And Battle knew that because she had talked with him. And you'll remember her mother even drove down to Valdosta because she says, I drove down there, I didn't even have a driver's license. I didn't care. I was going to find my baby. She did so much, we would be here for weeks to talk about the efforts Melissa, Cam's mom, made. And as I said, it was very unusual for Cam not to contact her. And Melissa testified that Cam had almost completed her schooling and was looking forward to that. She had been in contact with DFACS because Marissa Hanks had seen her on the August 11th. But they never heard from her again. She had been at Aspire on August 15th working on getting her psychological completed. Do you remember the psychological that the defense acted like there was some special reason she had to have? And Ms. Hanks said, no, that's for this kind of case, everybody on this kind of case has to have one. He had to have one too, he just didn't make no efforts. And we know she was at Aspire that day, because Ms. Hanks talked to her. No calls, no text. After August 15th, there was no initiation of calls, texts, messages, anything you can think of. There was no initiation from Lacambria Toomer to anyone. No signs of life. But there were pages of people trying to get in touch with her after August 15th. Pages. And not one person was successful. Not one person. Now, Lieutenant Peterson took over the case, but she had told you she had been Investigator Battle's supervisor, so she was familiar with the case. But she says, I want to start back and re-interview, do my own interview with the defendant. And what are some of the things the defendant says in the interview? Because they've been looking for this car. They've been looking for this car, this white Audi, the defendant's car. And what does he tell them? Well, it's his car, obviously, but it doesn't work. It doesn't work. He does not drive it. He has not driven it since June, and it's parked in Valdosta at S. Well, funny thing is that y'all saw on August 15th, it was parked in the Food Line parking lot. There it is, right there. The defendant, Ryan Cooper's white Audi, and on the passenger side, that window is halfway down, which means it's intact on August 15th. This was around lunchtime. This was around 12ish. The window is intact. How do we know it's Ryan Cooper? Because y'all saw the video with him walking to his car. And Lieutenant Peterson testified it was him. And we had previously seen him go check out. It's clearly him. Why would you hide your car from the police? There's only one answer, and that's because he knows what's in the car. He knows what happened inside that car. He does not want them to get a hold of the car. Because of all this, because of the blood, the headliner, all of that, that's why he's lying about the car. It was never confirmed that car was parked there. Matter of fact, they didn't even find the car until he got out of jail and they found out through his parents. Because his parents knew. Lieutenant Peterson had been talking with them, trying to find the car. They knew the police were looking for the car. The parents are the one that gave him up, gave his car up. And the defense alluded to the Family Dollar, where he went to Family Dollar in Albany a little after 8, which is on the screen. This is August 15th. right there on the screen. Well, he was at Family Dollar, so he wouldn't have had time to kill her. He wouldn't have had time to fire one gunshot from a little after 4 till after 12 midnight. Because that's how long, when they got back from leaving Tevin and them a little after 4, got back to Albany. He was in Albany riding around doing whatever. We know what he was doing. Till after midnight. And in the interview, when asked, have you used Cam's car? Mm-mm. No. I haven't used Cam's car. No. I have in the past, but not recently. Do you have Cam's car? No, do not have Cam's car. Do not have Cam's car. Well, first of all, we know from the testimony he used her card at both Food Line and Family Dollar on August 15th, the same day he was driving the car that doesn't work. We also know, because it's in evidence, that this came out of his wallet, Lacambria Toomer. We can all see that. He lied. Why? Because he killed her. Last thing with the defendant on August 15, 2022. We know that. We know he was at Tevin. We know he was at Tevin's house with her. We know Cam was there. And how do we know? We know from Joe Louis Jones, who's Tevin Davis's granddad. We know from Catherine Hall, who's Tevin Davis's the mother of his child. We know from Tevin Davis, and we know from the cell locations. There was an argument. The defendant was mad. If you'll remember, Tevin said when me and the defendant went to the liquor store, the defendant started basically freaking out, for lack of a better term, like, I hope she don't look at my phone. She better not look at that phone. And Tevin's like, wow, man, what's going on? Girls or something? He said, no, it's worse than that. And Tevin said, when we got back, we could see Cam's face. We could see the mood. We could see something was wrong on her face. And they get in an argument. She also spills something on his car, as Catherine testified to. He gets mad about that. He gets mad because she wants food or water. He gets mad for her going in the house. I guess he gets mad because she's breathing. Cam was crying. Cam, if you'll remember on the interview, Tevin's like, man, she was always blowing up that boy's phone, talking about his brother over here, Ryan Cooper. Cam, I told him to leave her alone. She just would not stop blowing up his phone. Man, that's some psychotic energy with her. That's what Tevin said on that interview. She would not stop. But yet, who did Tevin take up for that day? Did he take up for his brother? No. He took up for Cam. Man, you can tell she doesn't feel good. Let me get her some water. Let me get her something. They almost got in a fight over it. The two brothers, Tevin Davis and Ryan Cooper, the defendant. He's grabbing her out of the house. Tevin said he was tussling with her. He's getting her into the car. And he left. Tevin said driving aggressively. Catherine Hall said spinning rocks. She even told you, spinning rocks. Flying out in reverse, that driveway, because this is a gravel driveway. And Cam was heard screaming. Cam was heard screaming by Tevin. After they left Tevin, they went to Albany. We know for a fact. We know for a fact that Cam never left Albany, Doherty County, alive. We know that for a fact. We know that after August 15, 2022, her phone never used again, as far as on her end. We know that. Defendant, like I told you, he stayed in Albany. He left after midnight on August 15th. So, of course, once it's after midnight, it will be the 16th. He goes to Love's in Cordele. Now, remember, in the interview, and I think it's in the testimony too, he says he got to Love's in the afternoon. He said he was there a little over an hour. Because remember, he's in a rush to get to Savannah to pick up this load. He's in such a rush. But that's not true either. That's a lie too. That's a lie too. We know he got there shortly, sometime after 2 a.m. And we know that he stayed there at Love's truck stop 5 hours. Where he's supposed to have dropped her off. She got out of the car. Lieutenant Peterson told you, I reviewed hours of Love's video. Hours. Inside, outside, trash cans, trucks, the back where the big trucks are. I reviewed it all. Hours from the time period that he was there. Not one sighting of Cam. Not one. There is zero evidence Cam was alive in Cordele. Zero. Initially, when they found out that's what he was saying, they sent a Chris deputy. They didn't want to wait to send, they wanted somebody over there quick, so they sent a Chris deputy, Officer Foreman, to go check the video. He went inside, showed the workers a photo of Lacambria Toomer. They had not seen her. He looked at the video himself too. No. She was not walking around. No Cam. She was not walking around at Love's. She was not at Love's alive. The defendant told you through his interview he spoke with her on August 16th after she got out of his truck at Love's. The cell records say no, that's a lie. The cell records say it. We know that's not true. When they finally talked to Tevin Davis again, he told them, finally, he did, I think he was hesitant. Y'all can hear that interview. You can see him the first day on stand. He's hesitant. He said, look at the roof. Defendant told his brother, look at the roof. Tevin looked up, saw the little, like he described, blackish, reddish dots, looked like dry blood. The window was shattered. Tevin had been trying to get his phone back. We know that's a fact because we know he was calling the defendant about the phone. He told you that. The cell records prove it. And then the defendant continues to travel with Tevin's phone. The cell records and the cell data showed that. And we know Tevin had got his phone. He had to buy a new one because Tevin's phone had brains and blood on it, just like the defendant told him it did. He would not give him his phone back. And what else did Tevin say that the defendant told him?
Second question. What Lacambria at?
I don't know.
He ain't tell you nothing. What did he say he did to Cam? Go ahead.
No, you go ahead.
Go ahead. What he say he did to her?
It's some shit I'll never forget. Honestly. It's fucked up. Like, he shot her.
Mm-hmm.
I looked in the car.
Mm-hmm.
I looked at the roof. He asked me, he said, you know what that is? I said, no. I said, what is it? He literally told me, that's brains on the roof.
And Tevin testified when the defendant was telling him that he had a gun in his lap. He had a gun in his lap. And Tevin testified that he was worried about his family. Worried about his family. Remember, he said, I ain't worried about me, I'm from the streets, but I'm worried about my family. You don't know what somebody who's done something like this will do. That's what he said. Because the defendant's always carrying a gun. I mean, that's just been shown time after time after time. The aggravated assault, he had a gun. Catherine Hall previously saw it. Matter of fact, she didn't just see it, she described it. It's a Glock 19 extended mag. Tevin said on August 15th, while he was at his house, he had a gun. Because he kept it, he said he kept it right down here. By the seat in the console, right down here. That's where he kept the car. And remember, when Tevin's saying this to the officers about what happened, they've not went down and got all this stuff from the Audi yet. They've done that first search, but then they go back and say, wait a minute, we got to go get this car again. Because see, you got to see, after the first search, the car's gone back to the defendant. So they got to do another search warrant and go get this car. And we're just going to talk about all the search warrants. You just go through them. We're not going to go through each one. Y'all seen the evidence. But this photo right here, that magazine that's right there by the driver's seat, the console, that's where he kept the gun. Exactly what Tevin described. This is a magazine. The headliner with the blood. The headliner that's concentrated blood over the passenger side and then goes over toward the driver's side, but it's not as much because this is the person who got shot right here in the passenger side. And Engler testified about that. And Dr. Downs did too. A high energy event, and I can't think of anything else that would cause that kind of pattern except for a gunshot. And again, that's another close-up. And you'll have the headliner back there. You'll remember the GBI circled two places where they took the test from, the test that confirmed it was blood. And not only the test that confirmed it was blood, the test that they were able to get a DNA result that matched her mother, Melissa Thornton. And then, this window. You see this window. They go get the car. That plastic's over the window. Remember, Tevin said when he was driving it after August 15th, 2022, that he had some kind of like plastic bag, like a grocery bag or something over. At this point, he's got some plastic. I asked APD, I asked Billsby, I said, did y'all put that there? No, it was like that. Even Tevin said sometimes he'd park it behind the house and try to board it up. This window that wasn't gone on August 15th, 2022. And the testimony was that the window was either partially down or all the way down because of the amount of glass in the door. The door where the bullet hit and went through. And there was glass in the car too, fresh glass. And there's some of the glass in the car. And y'all have all these photos with you. And then in the door, the bullet hole. And Engler was saying how the door was most likely open because of the way it went in. And the copper fragments. But not only that, as that this went through the door, the foam of the door, all the way to the inside of the metal of the door, and protruded but did not go through the outside of the door. And we know what happened that day on August 15th. Because the window was intact prior to that. And the seat cushions, you'll have that. The seat cushions that the defense says, oh, that's not blood. Well, it is. When it ran down, they tested what ran off the cushion. They also said it is blood. The expert said it's blood. Every expert said it's blood. They know it's blood. We know it's blood. Initially, APD said it was blood. There's no one other than the defense that says it isn't blood. And remember, the console, you'll have that evidence with you too, where you can clearly see the blood on there. Clearly. And if that's not clear enough, look at this photo. You don't have to leave your common sense at the door. You don't have. How do we know it's blood? Well, we know that she's missing. We know that he's admitted to his best friend of shooting her. We have the bullet hole in the door. We have high velocity spatter on the top. We have her DNA. We have the blood running down the console. Oh, well, they didn't swallow that. No, if you remember, the testimony was a lot of the stuff they couldn't even get to until they removed the seats, till they started cutting stuff up. Engler told you about the patterns. What happened? How, when she's hit, that bullet goes this way, shatters the glass. The reason there's so much blood on the console because Cam's falling over on the console and it's just draining out, enough to fill up the bottom part of that console till it reaches that silver bar. And this was the demonstrative exhibit that Engler testified about what high velocity looks like. Looks pretty familiar. Looks like what's on the top of the defendant's car. And you got to remember, he cleaned the car. How do we know he cleaned the car? Because he told Tevin Davis he did. We know he cleaned the car. You'll have all these photos back there with you. He just didn't count on somebody removing the seat. Because see, that's the thing about it. When you commit a crime like this, you think you cleaned it up, but you start digging down deep, and what do we have here? You have the blood on the cushion. It has to be blood on the cushion, because it drained down and they tested it and it was blood. Again, the console, more draining from the back. And Dr. Downs, he said, like I told you, it's a high energy blood pattern. He said, I'm confident it's blood, as everyone else did, and it's Lacambria Toomer's blood based on the DNA match. And it led to her immediate death because by the experiment that he requested APD to do, they put 2.5 liters on their cushion, test cushion, which is in evidence. He said that the stuff, he had his hands on the stuff. The cushion, the headliner, all of it. More than 2.5 liters was in that car. And there is no way, unless she would have got an emergency transfusion within about 4 minutes, that she could have survived. And he said she died right there because there's nothing to indicate blood trailing out of the car. Like she left the car. She died right there. She could not have lived due to the blood loss. And well, we know, first of all, no person was treated within 4 minutes. Matter of fact, we know no person was treated at all in the area. He's confident that she is deceased and had never left the car. Mr. Edwards has went over most of the law with y'all. The judge is going to give you a copy once she charges you with the law. She's going to give you a copy of the jury charges, which is the law in the case, the law that you have to apply the facts to. And as Mr. Edwards told you, venue is one of them. That we have to prove as a state where the crime was committed. Has to be tried in the county the crime's committed. If it cannot be determined what county crime was committed, venue is proper and may be proved in any county in which evidence shows beyond a reasonable doubt that it might have been committed. We know she was killed based on the evidence in Dougherty County. And she was killed on August 15th. She was killed on August 15th, 2022. And if she was killed on August 16th, or 17th, or 19th, which we know she wouldn't, but if she was, It rolled over to midnight, it was the 16th. It does not matter. It does not matter. That's not even material. As long as we prosecute it in the time that the law says we have to. You can prosecute malice murder at any time. Any time. You can prosecute felony murder at any time. You can prosecute the remaining charges within 4 years, which we have. She was indicted in March. Actually, I'm going to give you the exact date. March 11th of 2026. As long as the remaining charges were committed between March 11th of 2022 and March 11th of 2026, which we know they were, that's what we have to prove. But we know from the evidence that Cam didn't survive August 15th. Mr. Edwards has already talked to you about malice. It does not mean ill will or hatred. It can be formed in an instant. An instant. You don't have to sit here and plan it, doing premeditation is not required. It's not like the things people think or see on TV. In an instant. We don't have to show why he did it. All we have to show is that he pulled up his arm and shot, which is clear. Again, Mr. Edwards talked about felony murder. You don't even have an intent to cause death. You cause it during committing a felony. Aggravated assault, assaulted a person with a deadly weapon. He sure did that when he shot her. And a firearm is a deadly weapon by law. Aggravated battery. We know that he seriously disfigured her because Engler testified he even saw pieces of biological material. Pieces of biological material. Skin, scalp. He said he saw the hair and could tell it had been that the hair and the blood had been as a result of the gunshot wound because of how the hair looked. How the hair looked and how the blood looked and how the skin or the, like I guess I'll say, biological pieces that he said he found. I would say if you get shot in the head, you're disfigured. You're disfigured. Testimony, Dr. Downs, which Mr. Edwards said was skull fracture, face caving in. We know he had a firearm. I mean, that's his thing. He has a firearm. He had it that day, and the day before, and the year before. We know he had a firearm because he shot her with it. And he concealed her death. Whether he put Lacambria Toomer in Albany when he was driving around for 10 hours, whether he put her in Savannah, which took him, he almost probably could have got to California by the time it took him to get to Savannah, whether he put her in Hawaii, does not matter. He concealed her death because all you got to prove is he concealed her death to hide or hinder the discovery of whether she was unlawfully killed, of whether she was murdered. And that's exactly what he did. The defendant is guilty of every count. It's not one or maybe two, no, every count. As Mr. Edwards said, by overwhelming evidence. Overwhelming evidence. He's guilty by the law, he's guilty by the facts, he's guilty by the evidence. And I'm asking you today, to bring Lacambria Toomer home. Bring